Look, I wanted to welcome everybody this morning. Thank you for coming. We understand, of course, that you didn't have a choice and that you're actually being paid for this, and it's actually during the workday. And part of the reason for that is because compliance is something that we should incorporate in every single thing that we do. So when we're verifying benefits, when we're out doing cases, when I'm reviewing contracts, we should all think of these things sort of with our compliance hat on, and that's why we think it's really important to almost shut down, for a substantial part of the day to go through this and refresh ourselves. Obviously part of this is about compliance with the OIG and our corporate integrity agreement, but a bigger part of this is just operating in accordance with our mission and values. And so, we can't stress enough the importance of this and following this. So I would really encourage everybody here to obviously pay close attention. I realize that over the course of 3 hours that, your attention may wax and wane a bit, but, we'll have some regular breaks, as Julie said. But it's really important, and to the extent that you have questions or issues or thoughts, please, this is a perfect forum for sort of getting them out there and discussing them. So without further hesitation, I will introduce our Chief Compliance Officer to start us.
Thank you, Bruce. Okay, I know what you're all thinking. What? Not this again? Yes? Yes, we are back here today because compliance training is an important company obligation under our corporate integrity agreement with the Office of Inspector General, or the OIG. But even if we were not required to hold mandatory annual compliance training, we still think that compliance training is important. And understanding federal and state rules and regulations that impact our business is a necessity in today's ever-changing healthcare environment. It can be daunting and overwhelming to keep up with the myriad of rules and regulations that we need to comply with in our day-to-day activities. Under the many changes in healthcare reform regulations, healthcare providers are struggling to understand the impact of healthcare reform on their organizations. Compliance programs have become an integral part of healthcare provider organizations and will become a requirement for all providers who bill Medicare and Medicaid in the near future. So compliance is going to be a requirement for everyone. Read all about it. Every day one can read about federal government's increased focus on preventing and deterring Medicare fraud and abuse around the country. In 2009, the Department of Justice, along with the Department of Health and Human Services, HHS, joined forces to create the Healthcare Fraud Prevention and Enforcement Action Team called HEAT. HEAT focuses their efforts to prevent and deter fraud and to enforce current anti-fraud laws around the country. They have set up Medicare strike forces in 9 cities, including Chicago. They have charged healthcare companies and individuals with various healthcare fraud-related crimes, including conspiracy to defraud the Medicare program, criminal false claims, violations of the anti-kickback statute, money laundering, and aggravated identity theft. The charges are based on a variety of alleged fraud schemes involving various medical treatments and services. Federal officials are working to ramp up their enforcement of existing medical privacy rules. Federal officials are also starting to target individual executives in healthcare fraud cases. Recently, it was reported that a Connecticut doctor will pay $2.2 million to settle government allegations that he billed Medicare and Medicaid for services that he did not perform. A doctor in Houston was convicted in a Medicare fraud scheme, and the list goes on and on. These were just a couple examples that, when I was working on putting together the slides, that I came up with. But literally every single day I get emails sent to me from the OIG which summarizes some of these cases. So the heat is on and we have felt the heat. Next slide, okay.
That was part of the
Yes, the heat is on, and we have felt that heat.
I'm impressed.
United entered into a settlement agreement with the OIG, as you'll recall, on July 8th, 2010, and also signed a corporate integrity agreement, which is called a CIA, with the OIG. United was required to pay the OIG $7.3 million. The OIG alleged that by soliciting and receiving payments from hospitals in exchange for patient referrals, United violated federal anti-kickback laws. As part of our obligations under our CIA, we are required to hold annual compliance training like we're doing today every year for the next 5 years. In fulfillment of this obligation, we are going to have 1 hour of general compliance training, which will include a review of our CIA requirements and United's compliance program, and 2 hours of arrangement training that will cover a discussion of the anti-kickback statute and Stark Law, obligations for all United personnel under our compliance program and CIA agreement, our arrangements tracking system, the policies and procedures related to our arrangement tracking systems, arrangements that could potentially violate the anti-kickback statute or the Stark Law, and some examples of violations, and some penalties that you could have for violating the anti-kickback or Stark laws. First, let's review our corporate integrity requirements. Who does the CIA apply to? It applies to all covered persons as defined as all United employees, officers, directors, managers, even to Dr. Norris and to Dr. Rubenstein. It applies to all leased employees, PRN employees, contracted employees that work more than 160 hours in a calendar year. It applies to all United physician investors. All future and current members of United Urology Centers are lithotripsy company. Some of the obligations in the CIA apply to a lesser extent to our physicians. For example, our physicians are not required to have annual training. However, we are required every year to send our physicians a letter that describes both our CIA and our compliance program. We've also made our CIA, our compliance plan, our code of conduct, and pertinent physician policies available to all of our physicians on our website with the physician access section. What is the scope of our CIA? It applies to all arrangements, and arrangements are defined as every arrangement or transaction that involves directly or indirectly the offer, payment, solicitation, or receipt of anything of value and is between United and any hospital actually or potentially receiving referrals from United or from United's physician investors. It also covers focus arrangements, and focus arrangements are defined as every arrangement or transaction with respect to the provision of green light laser and ESWL services, including providing equipment, supplies, technicians, and related items, that is between United and any hospital located in Illinois, Indiana, or Iowa, and that receives referrals from United or United physician investors for ESWL, XPS, HPS, with green light laser services. The CIA requirements, long laundry list of our requirements under our 38-page CIA agreement. The obligations include a written code of conduct. United has always had a code of conduct, even since the inception of the company, but we've had to expand that. Policies and procedures regarding the operation of United's compliance program, training and education, which is what we're doing here today, focus arrangement procedures, focus arrangement requirements, the engagement of an independent review organization or an IRO to provide reviews of our systems and an audit of our arrangements, a disclosure program so that employees and physicians can identify any issues or questions associated with United's policies, conduct, practices, or any other issues with respect to a federal health care program that's believed to be a potential violation of the law or United's compliance program. We need to have a process for screening ineligible persons and we do that against the OIG GSA exclusion list to ensure that United does not bill a federal health care program for items or services furnished by excluded persons. We have an obligation to notify the OIG of any investigation or legal proceeding by the government or any other agency for fraudulent activities. We have a policy for reportable events reporting, notification of moving or closing locations or business units. So for example, when we relocated the billing office and the administrative offices in February, I had to notify the OIG of that relocation. We also have an obligation to provide reports to the OIG. Our first report that we needed to provide was our implementation report. It was due in November. And now we have an annual report that will be due in September that we must report to the OIG for the next 5 years. So it's a long list of obligations under that CIA agreement. One of the obligations and requirements is that we have a compliance officer. We've always had compliance officers. In the past, we've had 2 co-compliance officers, Eva and Patty were our co-compliance officers. But as you know, I have now taken on the full-time responsibility as compliance officer. Most of you know me, but my contact information is listed on the slide, as well as posters that you may have seen. We've had posters in the fixed sites, in the garage, and there are posters with my contact information in the billing office. My responsibilities as compliance officer include development and implementation of policies and procedures and practices designed to ensure our compliance with our CIA, the training and education of our staff. You will see that I've added a compliance corner column to the employee newsletter and the physician newsletter, and the compliance column is a way that I can communicate different questions that I've received from physicians or staff with compliance issues, or any press releases or court cases or OIG advisory opinions that I come across that I want to communicate that I think impact our organization. So that's something that we've added to educate staff. The CIA requires the compliance officer to have active interaction with the managers. Anyone who's ever worked closely with either Dr. Norris or Dr. Rubenstein knows that that is no problem for me. I must periodically review our focus arrangement tracking system, review the focus arrangements to ensure that our policies are followed, and I must file reports with the OIG. I already mentioned we have one that's coming up in September, so that's another obligation. As a compliance officer, I and our managers were required to certify that United is in compliance with all requirements of the CIA unless an exception is noted in our report. United has implemented procedures reasonably designed to ensure all focus arrangements do not violate the anti-kickback statute and the Stark Law, and we must certify that United has fulfilled the requirements for new and renewed focus arrangements. The managers must review my report, and they must certify that they've made reasonable inquiry regarding its content, and they believe that the information in the report is accurate and truthful. So all the 2 managers and myself, all 3 of us, are required to certify that our report that we're submitting is truthful. The CIA requires that we report to the OIG within 5 days the change in the compliance officer or a change in the compliance officer position description, or any actions or changes that have occurred that would affect my ability to perform my job under the CIA obligations. Let's talk a little bit about the requirement for an independent review organization. The independent review organization, or as I mentioned, it's called an IRO, is exactly that. It's someone that United must retain to review our focus arrangements tracking system and to conduct an audit or a review of any new or renewed focus arrangement contracts for lithotripsy, XPS, HPS laser. The IRO will audit a random sample of 25% of new or renewed contracts for the reporting period. The IRO must be someone that is knowledgeable in anti-kickback statute and Stark law. We just recently had our IRO in last week. Some of you may have seen that we had a couple of visitors. That was the IRO, and they conducted their audit of our focus arrangements. They audited 23 of our laser contracts and 16 of our lithotripsy agreements, and we did very well during that audit. But the IRO now will prepare a report, and they've also finished their audit of our system review, and they're going to prepare a report on that as well, and then they submit those reports to the OIG. What if we fail to comply? If we fail to comply fully and timely with our CIA, there are stipulated penalties of $2,500 per day for the failure to do or have any of the following: a compliance officer, a written code of conduct, written policies and procedures, training, focus arrangement procedures and or focus arrangement requirements, a disclosure program, notification of governmental investigations or legal proceedings, reporting of reportable events, engagement of an IRO, or if we would fail to submit a report that is due under the CIA. There's a $5,000 per day penalty if we falsely certify any of our reports to the OIG, a penalty of $1,500 per day for failing to grant the OIG access, and a penalty of $1,000 per day if United does not fully and adequately comply with our obligations under the CIA. So it's very serious if we don't comply with the CIA, because there are penalties that can be imposed. If there's a material breach of the CIA, United and its managers could be excluded from participation in the federal health care program. A material breach would be our failure to report a reportable event, to take corrective action and make appropriate refunds. We're going to talk a little bit later about this, but Medicare now requires that refunds are made within 60 days, or if the OIG had asked us to refund any money and we neglected to do that, that would be considered a material breach, or a repeated or flagrant violation under the CIA. Our failure to respond to a demand letter regarding penalties, or our failure to engage and to use an IRO. Now we're going to talk a little bit more specifically about our compliance program. United has had a compliance program in place for many years, but last year it was reviewed and updated to comply fully with our CIA. Our compliance program facilitates the establishment of a culture within United that promotes the prevention, detection, and resolution of instances of conduct that do not conform to federal and state law, federal and state and private payer healthcare program requirements, as well as our own ethical and business practices. One of United's core values is integrity. We promote a corporate culture that is consistent with the highest moral and ethical principles in our relationships, whether those relationships be with our patients, our physicians, our facility partners, our vendors, or with each other. You have heard many times the phrase, "do the right thing." This has been our corporate message from our managers on down since our inception. One of the most important components of the compliance program, and really at the core of it, is our code of conduct. The code of conduct affirms our commitment to fully comply with all federal and state healthcare program requirements. United's code of conduct sets the standards for our employees and our physicians in the conduct of our business. All covered persons, employees, the managers, leased employees, PRN employees, and all physician investors must comply with all federal healthcare program requirements and United's policies and procedures. All covered persons must sign an acknowledgement that they have read and understood and will comply with the Code of Conduct. The Code of Conduct requires all employees and physicians to comply with all federal health care program requirements and with United's policies and procedures. If you do not comply, it will be reflected in your performance review. Promotion of and adherence to the Code of Conduct is an element in evaluating the performance of all employees. Some general matters that are covered in United's Code of Conduct apply to physician conduct. Since our lithotripsy company is a physician-owned company, United Urology Centers, United provides disclosure information to our patients regarding physician ownership. You may have seen this disclosure. It's in our patient consent forms. Physicians will not negotiate business on behalf of United. Physicians will not receive any payment in cash or in kind for the referral of patients. It's illegal and it's also unethical to offer or solicit any financial inducement, gift, or anything of value to prospective patients or others to encourage patients to be treated at United. We also do not disclose any information regarding the number of cases a physician performs to anyone other than that individual physician. If requested, we can tell a physician what his or her own case volumes are, but not the case volume of any other physician. And you might wonder why we can't do that, but there are times when, and I know in the past, physicians may have called me and they wanted to know how much another doctor, how many cases they were doing. And the reason they wanted to know is they wanted to make sure that they were doing, their share of the load. And they may go back to that physician and try to get them to do more. And so that is just something we cannot tell our physicians. We can tell, though, it is permissible to tell our physician investors the total number of cases that the company does in a month or in a year. It's not permissible to require a number of cases to be performed before permitting a physician to invest in the company. And likewise, it is not permissible to use case volume to determine if a physician may purchase additional investment interests. We have a sale of membership interest policy, and it's applied consistently and fairly to all of our physicians. Another element of the Code of Conduct has, Bruce?
I have a question. I met with a physician last week, and I was talking to him about the facilities in his area, 3 different hospitals. And I didn't tell him the contract rates, but he specifically asked me if he could have copies of those 3 contracts. And I told him that, we can't.
Right, there would be no reason for that physician to have copies of the contracts. If you wanted to know like the schedule of services but I can see no reason that we would give that. So very good. You handled that just correctly.
I'd say not only as far as compliance goes, would I not do that, I think that's a poor business practice. That's proprietary information. So
right.
I would have never wanted. That's within the company alone, and there's no reason for them to do that.
But physicians do ask that, and a lot of times they'll want to know specifically what our case rate is at a hospital, and we don't tell them that either. They do not need to know what we get paid. We'll talk about the employment part of our Code of Conduct. At United, we recognize that our greatest strength lies in the efforts and talents of our employees. We provide an equal employment opportunities to current and prospective employees that are based solely on merit, qualifications, and abilities. United values its employees and will pay employees fairly and will provide a safe and healthy work environment. United prohibits any individual from engaging in any act or form of harassment of any other individual on the basis of that person's color, race, religion, national origin, handicap, or sex. So we follow all the labor laws here. Another aspect of the Code of Conduct involves quality of care. At United, delivering exceptional patient care is the core of our mission. We have a patient Bill of Rights that includes the mandate that all patients will be treated with respect and with dignity. All treatment we provide will be medically necessary, and we will make no distinction in the care we provide based on one's ability to pay. All employees will be licensed, credentialed, and skilled for the services they perform as required by law. United will comply with all laws and regulations regarding patient rights and privacy, including the Health Insurance, Portability, and Accountability Act of 1996, or HIPAA. On a periodic basis, through its QI and Compliance Committee, procedures and standards will be reviewed to ensure that the patient care we provide at United remains of superior quality. The Code of Conduct provides a brief summary of a more detailed confidentiality, non-compete, and conflict of interest policy standards. And every year, we provide our employees with an addendum to that policy that they must sign. Jackie actually has them today for everyone. Basically talking about, that we would all adhere to this policy of confidentiality, non-compete, and conflict of interest standards. Employees must avoid any personal interest or association that may be inconsistent or even appear to be inconsistent with their dedication to serving the best interests of the company. United's ability to compete with others and its choice of those with whom it may do business must not be reflected by the personal interests of any one employee. Employees are required to report any actual or potential conflict of interest that arise in connection with any offers of incentive payments or free items or services offered by suppliers or our vendors. There can be no offer asking for paying or receiving anything of value in return for the referral of patients. Employees cannot accept gifts from facilities or vendors. Only items of a nominal value would be okay. Marion always talks about cookies at holiday time. Policy guidelines must be followed for the entertainment of hospital personnel. On rare occasion, it is okay to take someone from a hospital out to lunch to discuss a contract. However, what you may find is that hospital person isn't able to go out because they're also held under similar standards with their own conflict of interest policy. United may provide refreshments or sponsor a dinner to make a pitch to potential investors, but the value of that meal per our policy should not exceed $100 per person. No other thing of value, such as bottles of wine, gift cards, or gift certificates, may be provided to potential investors. No spouse or guest can attend unless the office person that is invited to attend is pertinent to the topic that's being discussed. For instance, if you had an office manager attend a meeting and you were talking about how to schedule cases, that would be okay. Yeah?
Back to slide 30.
Okay.
I know this is specific to our code of conduct.
Right.
What if you learn about another competitor that is offering
inducements
for business to
well,
hospital administrators? And
if you do hear about that, you should let Bruce or myself know, and we could take that to our attorneys and see how to follow through on that. So, thank you. Okay, so now we're at marketing. United is committed to implementing its marketing and entertainment in compliance with fraud and abuse laws. United may provide refreshments or a modest meal at a meeting to market its service to physicians. However, no employee may offer anything of value to a potential or existing investor in order to generate referrals or to gain assistance to help us negotiate a contract. As it said on that slide, logos, pens, things of small value, those are okay. Okay, then off-label use, I just wanted to make a few comments on that, what that means and what that's all about. Once approved by the FDA, a manufacturer may not market or promote a drug for any use that's not specified in the FDA-approved product label. These uses are also known unofficially as off-label uses. A recent case that actually was just settled 2 days ago involved a Belgian pharmaceutical manufacturer which pled guilty to the off-label promotion of its epilepsy drug called Keppra and is required to pay more than $34 million to resolve criminal and civil liability arising out of its illegal conduct. Keppra was approved by the Food and Drug Administration as an anti-epileptic drug for the treatment of seizures in adults and children suffering from epilepsy. But the company disseminated posters and marketing information representing that Keppra could be used safely and effectively to treat migraines. And this was based purportedly on their independent investigator-initiated studies. The posters did not disclose that the company had actually sponsored these studies. So you cannot promote any product or device for an off-label use. Physicians, on the other hand, can use a device or medication off-label, but they cannot advertise for it and they cannot promote it. So there is a difference there. Code of Conduct has some standards for if we would receive a subpoena or other type of communication. If an employee receives a subpoena, an audit letter, or any other communication from the government that requires a response from United, the employee should give that information requested to me or to Bruce immediately. All employees are required to report any contact, inquiry, investigation, proceeding, charge, or complaint involving any court of law or state or federal agency that is related to United or its operations. If a subpoena, audit letter, etc. is received, or if notified that one will be received, no documents can be destroyed and no emails can be deleted. Any employee or physician must immediately notify me in writing if they become the subject of or if there is presently or pending a request for information, inquiry, investigation, or proceeding, the outcome of which could result in that person's suspension or revocation of licensure or certification, or if they are excluded, suspended, or removed from any government or commercial payer plan or program. United is committing to ensure that its contracting practices comply with federal and state laws, regulations, guidelines, and policies. A hospital must never be pressured to accept contract terms in order to obtain or to maintain their referrals. A fundamental tenet of both the federal anti-kickback law and the Stark law is that items and services are provided at fair market value. A physician may introduce United to a hospital, but that's usually the end of that involvement. The physician must not participate in the negotiation of the contract. United may not enlist a physician to help secure a contract, and physician referrals must not become part of the negotiation process. No one may threaten or imply that if a contract is not obtained or renewed, the physician will take his patients to another facility. Services should not be provided unless there is a written contract in place that is signed by both parties. Now, for laser services, we were given an exception to that because sometimes it can take a long time to get a countersignature on a contract for laser, and we have patients that need to be treated. So as long as we document our efforts that we took to get that signed contract back, and as long as we've signed the contract and sent the contract, then we're okay to do services. All of our focus arrangements are reviewed by our healthcare council, and then they're approved by me. The Code of Conduct has always had a lot of standards that impact billing and billing staff. All coding has to be accurate. If it's not documented in the patient's medical record, you've heard this before, then it didn't happen. Billing must ensure that charges are entered for the services we provided and that we checked on the text sheet or encounter form. We only bill for services using the appropriate CPT code. We cannot upcode for services. Upcoding is when a provider bills using a code for a higher paying service than what was actually performed. For example, a physician does a photo vaporization of the prostate, but that physician knows that if he bills using the CPT code for enucleation, he'll get a higher reimbursement rate. That's illegal, and that's called upcoding. We follow a messenger model for physician professional fee contracting, and we ensure that all physician fees are kept confidential and that each physician determines his or her own fees. We cannot bill for any drug samples or any free items that we receive. All refunds, once identified, must be refunded within 60 days or according to the terms that we may have worked out with the payer. As I've already mentioned, Medicare now has very strict rules that any identified refunds must be returned within 60 days. There was a very well-known case involving urologists that had billed for drug samples. And I'm just going to read this, but several urologists pled guilty to charges of conspiracy, paid restitution in the tens of thousands of dollars, and received sanctions against their medical licenses for billing Medicare for injectable prostate cancer drugs they received for free from 2 pharmaceutical companies. The pharmaceutical companies paid $1.4 billion for their part of the alleged scheme to give urologists free samples, and they encouraged them to bill Medicare at inflated prices. The pharmaceutical companies also provided urologists with additional inducements to use their drugs over the competitors' products, including drug rebates, grants, volume discounts, free goods, and debt forgiveness. So this was a very famous case.
Shine, shine, shine.
Julie,
Yes,
I have a question.
sure.
So if a physician calls the billing office during the time when we update our charges,
Mm-hmm.
and the physician asks someone in the billing office, you know, I don't know what to charge.
Mhm.
What are other physicians charging?
Well, I would never specifically give any individual physician's information out. In the past, when I have gotten that question, I have encouraged them to use sources. There's published sources where a physician can go and they can obtain the range. They can obtain the 90th percentile, bless you. And so there are sources that they can use to get an idea, but we shouldn't be giving them or helping them with those charges.
I'm not sure if that's a compliance problem, it may not be, but it's a federal trade problem. In other words, it's innocent, but you cannot tell another doctor what you're charging. Even I say, John Jones says, well, what are you charging for this procedure? I really can't tell him that, and I don't. That's not his business, but that's not a compliance problem. It's an federal, FTC problem.
Antitrust
So,
issue.
It's a whole different thing. So
Right.
It shouldn't be done.
Okay. Our code of conduct applies to our treatment of co-payments and deductibles. We make every effort to collect a patient co-payment and deductible. Routine waiver of co-payments and deductibles is not permitted, and patient balances are only discounted or waived in accordance with United's Charity of Care policy. We do not offer professional courtesy, and as a physician-owned company, this could be interpreted as an inducement, so we don't do it. We have code of conduct rules to follow related to the offering of investment interests to physicians. Only urologists may be offered interests in United Urology Centers without any requirement to use the services in order to invest first. Physicians cannot be required or pressured to sell interests if referrals are low or if they do not use our services. All investment interests must be sold and purchased back at the fair market value rate. And that's why on an annual basis we go out and get a valuation of what an interest in the company is worth. When we start a new company, we make sure that the investor contributions are sufficient enough to capitalize the company, and pro formas are not used to induce physicians to invest with high inflated rates of return. You all are the eyes and ears of the company. If you suspect there's been any violations or potential violations of any federal health care program, the violation of our code of conduct, our policies, our procedures, federal, state, or local laws, as your compliance officer, I will investigate any and all reports. One of the things that we're required to have with our CIA is a form of disclosure, and so we do have a disclosure program. It's a way for our employees and our physicians to report compliance concerns. You can email me, or you can call me at work, or you can call me on my cell phone. All this information is available on posters, as I mentioned, at the fixed sites or the garage, or even in the billing office, and you can stop me too. I would rather have you stop me or call me to discuss the concern that you may have than to have a potential compliance problem that goes unresolved. Yes?
Let's say you send an email to a doctor and you realize that maybe you made a mistake, that it could potentially be a violation, and you're worried about getting in trouble if you've done something wrong. First of all, if it is a violation, what's your obligation as the officer to the OIG? Do you have to go to the OIG and divulge what happened? And can we get in trouble if we come clean, if it was a mistake?
Well, okay. We have had some emails that have been brought to my attention that could be problematic. I think the most important thing, and we're going to talk a little bit in the second session more specifically about emails, but is if you get an email or you send an email and you think it might be problematic, don't just let that be the end of it. Some of the sales reps have received some emails from some physicians with the physicians maybe saying that they were going to get somehow involved in contract negotiations. What you need to do is respond to that email, and that's what we've done. In some cases I have consulted our attorney, but in most cases either I or Bruce can formulate a response to send back that shows a trail that we didn't request them to get involved, and then we've tried to discourage that, and so we have the paper trail. If you send something and then later you think, oh, I shouldn't have sent that, again, I think it's something that you should follow up with and clarify. Depending upon what the nature of it would be whether or not we would have to disclose it or report it to the OIG.
But I won't get in trouble if I make a mistake and come clean.
They'll be a lot more lenient with you. Your sentence might not be as long. Okay. If you do report a compliance issue or concern, there will be no retaliation or retribution for reporting. We want to hear if there's a problem. In most cases, they can be easily resolved. If you feel that you've been retaliated against because you did report a problem, report that issue to me. Anyone found retaliating will be disciplined and possibly terminated. You have different reporting options. As I mentioned, you can call me directly or email me, but you can also call our compliance hotline. And that is the number there for the compliance hotline. The compliance hotline is a toll-free number that you can report compliance concerns, either identifying yourself, or if you don't wish to do that, you can report a concern anonymously. If you report a concern anonymously, that's fine, but it may be more difficult to go ahead and investigate your issue because I can't get a hold of you to find more information. If you do report anonymously, give as much information as you can, and if later you have more to report, call the compliance line again and report more information. If you do report a concern, we will make reasonable attempts to keep your report confidential, but there could be instances that by the context of what you're reporting, you reveal your identity. But we will try to keep reports as confidential as we can. Okay, we have a compliance committee. You may not be aware that we have a compliance committee, but it meets every quarter after the quarterly QI meetings. The committee members include Dr. Norris, Bruce, Patty, Eva, Bill, Tom, and myself. The purpose of the Compliance Committee is to assist me with implementation and maintenance of our program, to work with staff to develop standards of conduct and departmental policies and procedures to promote adherence to our compliance program. And recently, we started a risk assessment program to identify areas in the organization of high risk and to audit and monitor those areas. Operations has a policy regarding compliance audits, and this has been in place for many years. But each quarter, 70 charts are randomly selected and audited for their accuracy, their completeness, their adherence to Joint Commission standards. We aim for a compliance score of 95% or better, and any staff that's identified with ongoing deficiencies, they're given further training and they are monitored. We also match up the medical record with the billing encounter form or the tech sheet to ensure that we accurately billed for the services that were completed. The billing office also has a quarterly audit, and it's an extensive audit. Their audit is to ensure that all aspects of the billing process are completed accurately and timely according to guidelines each department has set. Again, the tech sheet and the charge batch are compared for accuracy. Records are checked to ensure that the correct physician was selected at charge entry. And we look at insurance claim rejection reports to identify any patterns or trends. We look at the EOBs and the site invoices, and those are audited for accurate billing and payment posting. So we have a couple of audits going on throughout the company. Our policies and our procedures. The Code of Conduct references several more detailed policies and procedures. In the past, last year, we passed all the supporting policies and procedures out to you. This year, we're not going to do that, but you can obtain any more detailed policies by either going to the Corporate Forms and Lists N drive, if you have access to that, or the employee portal of the internet. And it's under the username of United Therapies, and the password is UT123. That was in one of our employee newsletters. A very important compliance policy is the OIG exclusion review screening. Individuals excluded from participation in federal or state health care programs, for example, Medicare, Medicaid, or TRICARE, may not work in any capacity for a company that directly or indirectly receives payment from these federal health care programs. An excluded company cannot provide lithotripsy services to a hospital. United will not engage in any business relationships with any ineligible individual or any entity, as defined as anyone who is currently excluded, debarred, or otherwise ineligible to participate in federal health care programs and listed on the OIG exclusion list or the GSA excluded parties list. We cannot employ any excluded individual, and an excluded individual, a physician, cannot be a United investor. The effect of exclusion is very serious. It would be a violation to bill for services that were provided by anyone that's on the exclusion list. All money that is received from the services provided by an excluded individual would need to be refunded, and it's a reportable event under our CIA. We would need to report this to the OIG.
So I have a question.
Sure.
So let's say we have a verifier,
Right.
for example, that all of a sudden we discover sort of because of an alias, not an alias, but a married name or this or that was on the excluded list. I mean, how does that play into, I mean, would it be just cases that that person specifically verified that might be subject to?
Well, first of all, the person probably wouldn't be hired because at the time before the offer was made, if they're on the OIG exclusion list, we wouldn't make the offer of employment. But during the course of it, if they became on the list, if it isn't anybody that's central to providing patient services, we would probably go back and try to find out from the OIG what we would need to do. I don't think a verifier we would have to worry about.
Okay.
So sometimes I think Marion had reported last year that the most common reason individuals are excluded is because they haven't paid back student loans. So
What?
haven't paid back student loans. That's the most common reason.
That excludes them from healthcare?
Yes,
Really?
yes. So.
Oh,
So let's talk about screening. Why is it required? Per our policy, we screen all prospective employees prior to offering an employment, and we screen all physicians prior to granting practice privileges and on an annual basis thereafter. An eligible person also includes anyone who is convicted of a criminal offense for which exclusion is mandatory but not yet excluded, debarred, suspended, or otherwise declared ineligible. Currently, there's over 5,200 physicians alone excluded from participating in federal and healthcare state programs. We screen using the OIG list of excluded individuals and the General Services Administration list of parties excluded from federal programs. HR performs our employee screenings, and credentialing screens all credentialed physicians. We also check maiden names and any known aliases, and this information is on both our employment application and our physician credentialing applications. Focus arrangements. Since our CIA, we have written and implemented policies for our focus arrangements to ensure compliance with federal laws and our CIA obligations. All focus arrangements are in writing. All parties must sign the agreement. No services are to be provided without a written contract. We even have a written demo agreement that we can use to start treating cases while we negotiate a longer-term agreement. We have certification in the contract that the parties to the contract shall not violate the anti-kickback statute and the Stark Law, and we have to have a policy in place for record retention and access. We've developed a procedure to initiate new focus arrangements. This was developed in one of our first departmental-wide Kaizen events. We have a detailed policy and various checks and balances in place to ensure that our focus arrangements do not violate the anti-kickback statute or Stark Law. We have developed a centralized tracking system using an access database, which we term FATS, Focus Arrangement Tracking System, for all new and renewed focus arrangements. We're going to go into greater detail in the second session, but just to tell you right now, FATS complies with all the tracking requirements, and we've made it so it does, that are spelled out in our CIA. Jim Snelson, our Director of Provider Contracting, enters contract information into the database. We have our regulatory counsel review all of our focus arrangements for compliance with anti-kickback statute and Stark laws. And if there are any suspected violations discovered, we must implement an effective response. We must track the remuneration we receive other than the per procedure rate. We must have a business need or rationale. Almost always the business need is that the facility needs services, but we have to provide that information and track it. If our agreement is for lithotripsy, we must document and determine fair market value compensation. There are several areas in our company that we may encounter compliance concerns, and I thought what I would do is try to go over some of these areas and kind of make it more practical to your day-to-day activities. The first is the conflict of interest. We all know that conflicts of interest occur when decisions or actions regarding patients are influenced by personal or professional interest. Some instances that could potentially give rise to conflict of interest are purchasing or ordering of supplies. We should purchase supplies based on established criteria such as price, quality, and service. Gifts and entertainment. Do not accept gifts or services or entertainment or other items from a vendor. These may impact your decisions. Use of the company's property. The company's property and assets must only be used for legitimate business purposes. So those are some areas. Patient care. The way we treat our patients is the center of our reputation as an honest, fair, and ethical organization, and it supports our corporate value of integrity. We should always provide care to patients without regard to their race, religion, ethnic origin, gender, age, disability, or sexual orientation. We should communicate to our patients in a manner and a language that they can understand, and that's why at the centers we use the language line. And we should appropriately chart and document all the care that a patient receives. Privacy and confidentiality. We respect a patient's right to privacy and confidentiality. These rights are not new. But with HIPAA rules and regulations, there are penalties for violating a patient's right to confidentiality. We must adhere to all HIPAA privacy rules. HIPAA gives patients the right to have their information kept private and confidential and secure. Only staff members who need to know PHI, which is Protected Health Information, I'm saying some of these slow because hint, hint, it might be an answer later, to perform their jobs have access to it. Only the minimum necessary information to perform a job can be shared. We must take safeguards to protect PHI. For example, we make sure that our medical records are kept locked in file cabinets. We make sure that only those who need access to electronic data have it. Computers must be turned away from public view. We no longer post a list of the patients like we used to do in the centers with the names. And all PHI must be destroyed appropriately. And that's why we have shredders throughout the centers. As was recently noted in the compliance newsletter, a healthcare provider, Signet, was fined $4.3 million for HIPAA violations. They refused to provide patients with their medical records, and they failed to cooperate in HHS's investigation. Massachusetts General settled recently with HHS for a $1 million HIPAA violation when it was discovered that one of their employees had inadvertently left 192 patient records on the subway with PHI information. As I mentioned earlier in one of the first slides, the government is working to ramp up their enforcement of medical privacy laws. In some cases, it's not malicious or intentional, it's just bad luck. Two of Highmark's most recent breaches, one from this year, involved torn mail envelopes or packages that contained insurance plan rosters. Another one involved a manual error in which an email that was intended for a law firm was inadvertently sent to another Highmark group customer. And then there was another HIPAA violation settlement with Blue Cross Blue Shield, which was caused when there was a stolen laptop from an employee. Another recent one is July 6th. HHS entered into a resolution agreement with the University of California in Los Angeles to settle potential violations of HIPAA privacy and security rules. They settled for $865,000, and they have to have a corrective action plan. And what happened in that case is some of the employees disclosed the identity of a few celebrity patients. I think one was Tom Cruise. Okay, another area of concern is our red flag rules. The Federal Trade Commission has even gotten into the legislation. We must adhere to the red flag rules, and these are aimed at protecting consumers, including patients, from identity theft. We require our patients to provide a photo ID. We verify demographics prior to providing services, and we protect the financial information we obtain by maintaining it in a secure place and with secured access. We shred all, bless you, we shred all patient credit card information, and we prohibit the sharing of passwords. Safety and health are other areas that are very highly regulated. We comply with all governmental rules and regulations that promote the protection of workplace safety and health, such as all pertinent OSHA requirements. We've developed our own safety program and safety-related policies. We follow proper procedures to handle and dispose of hazardous and infectious waste. United requires its employees to report for work and to perform their assigned duties competently and efficiently without impaired judgment, impaired coordination or skill, and in a manner that does not jeopardize the health and safety of patients, visitors, and other employees. Employees should report any communicable disease exposure to your supervisor. Lots of areas of concern for billing. We need to ensure that we follow not only our own contractual obligations with our contracted payers, but we also need to ensure that all of our billings conform to pertinent state and federal laws and regulations. We should not present any false claims for payment that are false, fictitious, or fraudulent. You may wonder who would ever do such a thing. But a couple of days ago, July 14th, 2 doctors in the area were charged and were indicted for fraudulently billing Medicare and Medicaid, and it was $24 million that they had billed for services that were not performed. And the doctor, you may have heard the name, is Gautam Gupta. Yeah, because he, I know the name because his weight loss clinic was right next to a facility where I work out. And he advertised heavily in the Chicago area. And he and his partner from Rockford, they both were indicted and charged. The OIG even has its fugitives most wanted list. And it's almost like a list that you might see in, in the old movies in the post office, where it actually has pictures of their most wanted fugitives. And sometimes I get posts from the OIG that they've caught up with one of their most wanted. It's like a television show. So to end this session, the bottom line is, and what everyone should take away, is that you need to stop. If you see a problem, think about, why is it a problem? Ask yourself, is it legal? Does it follow United's policies? Is it ethical? How would it look and how would it sound in the newspaper? Am I treating others like I want to be treated? Is it in the best interest of the patient or the customers? Then act. Act on it. If you don't know what should be done, then just ask.
Well, you've heard this